For example, what kinds of tasks are stablecoins capable of doing that XRP is not, and vice versa? You have a very good question. We consider them to be complementary and additive to one another. In the context of payments, in that aspect of our company, there are a lot of use cases in which the client wants to see the transaction through in United States dollars, or maybe it's just the most cost-effective alternative. In other words, there are a lot of use cases, and when you consider important routes such as the US dollar and the euro, you will see that there is a great deal of liquidity there. You do not actually require a bridging asset such as XRP at this time. In the manner in which they had always discussed it, those individuals were the ones who had invented the ledger. Moreover, when I go back to the very early days of Ripple, the topic that we had always discussed was the use case for a neutral cryptocurrency as a bridge asset. This is something that I find really interesting. Like XRP in this instance, there are going to be a wide variety of goods that are going to be tokenized on-chain in the future of the Internet of Value. Additionally, in order to have very efficient cross-currency or cross-token settlements, you will require an asset such as that. This is more of a long tail. To simplify, it is more the long tail of assets and currencies where the costs are. When you think about it in the context of cross-border payments, you have different currency crossings between, for example, a country in sub-Saharan Africa and a country in the Middle East or Europe. On the other hand, the liquidity is not quite as high. These expenses are really substantial. For a payment of that nature, I could be required to pay fees that are greater than 10% of the whole amount. Therefore, we believe that here is where XRP will play a role. There have been two separate instances in which the Supreme Court has made a rule that is in opposition to the Securities and Exchange Commission, and Coinbase has also initiated legal action against the SEC during this time. This has had a significant impact on the cryptocurrency sector because it has helped to establish legal clarity for cryptocurrency in the United States. As a result, the industry has been badly impacted. The tremendous overreach of the Securities and Exchange Commission, which is known for its discriminatory practices, has been overturned by the courts. This has made it more difficult for the SEC to file new false claims against any player in the cryptocurrency environment, including those who are participating in the ecosystem of XRP. There is still the risk that additional false claims could be brought against any party, including Ripple, for any reason that is not founded in reality. There is still a risk about this scenario. A number of recent legal losses have resulted in an increase in the amount of CRIP in the United States, which has led to a decrease in the possibility of the Securities and Exchange Commission (SEC) attempting to implement such measures. Is it appropriate for the federal courts to defer to the discretion of reasonable federal agencies in situations when legislative statutes are unclear? The decision about Chevron defense was issued by the President in 1984, as stated in the Chevron defense judgment, which was later overturned by the Supreme Court. This ruling is extremely important for the Bitcoin industry, as well as other firms that have been subjected to uncontrolled rulemaking by agencies such as the SEC, which has provided courts with a larger degree of freedom in interpreting the law. It is possible that this decision is the most important piece of information that has ever had an impact on the Bitcoin sector. This is due to the fact that it suggests that the Supreme Court's interpretation of the Howey test, which is used to establish whether or not crypto assets or securities are relevant in court, is no longer applicable. In its place, the courts will now base their decisions on the law, which may lead to outcomes that are different from what the Supreme Court might anticipate in accordance with the Chevron deference principles. Please give it a big thumbs up, hit the subscribe button, turn on notifications, and feel free to join our community before we begin. This will provide you with all the information you require regarding XRP. Who is running for Senate against Elizabeth Warren, has expressed his disapproval of the decision that the Supreme Court made regarding Chevron. He has characterized the ruling as a power grab by the extreme right that is intended to favor those who are wealthy and well-connected. As a consequence of the decision that was handed down by the Supreme Court, elected members of Congress are compelled to carry out their responsibilities and approve legislation that expressly permits a federal agency to carry out the operations that it is attempting to carry out. As a result of this, it is clear that senators in the United States will be required to become less political and work together in order to find a consensus, rather than relying on partisan hacks like Gary Gensler. The decision of the Supreme Court of the United States regarding the overturning of Chevron appears to have been crafted with the Securities and Exchange Commission in mind, according to James Murphy, an attorney who is also known as the Metal Lawman. Murphy made this statement: "It is Chevron defense that is to blame for the unneeded instability that is present across the entire court system. Persons who are attempting to plan around agency action are left in a condition of continual uncertainty as a result of this. Because of this, there is currently a lack of clarity around the regulatory framework that governs the Bitcoin industry. In addition, the Securities and Exchange Commission has been making things up in order to maintain control. It is becoming increasingly difficult for the Securities and Exchange Commission to bring new charges against any member of the cryptocurrency ecosystem, including those in the Ethereum ecosystem. This is because of recent occurrences, notably the most recent one, which has made it more difficult for the SEC to bring charges against existing members. It is true that the Securities and Exchange Commission is less likely to take such a step as a result of these developments, which may result in a rise in the quantity of cryptocurrency in the United States. Specifically, the Securities and Exchange Commission has taken legal action against Consensus, the parent company of MetaMask brokerage staking service, on the grounds that the company is allegedly in violation of federal securities laws. In contrast to the Ethereum Exchange Traded Fund ETF, the Securities and Exchange Commission (SEC) has been criticized for its actions, which include allowing Kim Jong-il to continue his campaign against cryptocurrency in any way that is sanctioned by the current government. The regulatory environment has been altered as a result of the decision that the Supreme Court made over Chevron defense. As a result of this ruling, unelected bureaucrats at the Securities and Exchange Commission have less authority to make things up. Because of this change in the regulatory environment, there is a possibility that the industry will become more stable and transparent as a result. Must refrain from making decisions based on their own opinions or the political convictions they hold today. A number of assertions were made by the Securities and Exchange Commission in response to the Wells notice to Consensus. One of these assertions was that Ethereum itself was a security. Once again, during the election season, the Securities and Exchange Commission gave its approval to the spot at the ZT file, despite the fact that they did so with some reluctance. This was a consequence of the situation described above. For those specific reasons, the Securities and Exchange Commission was no longer able to pursue legal action against the session. As a result, the possibility of prosecuting the session was no longer viable. They clarified that the investigation into him had been terminated in a statement that was disclosed to the public. Nevertheless, they also made it quite clear that the consensus had not been disproved and that additional charges could not or would not be brought against the defendant. Several individuals, including a member of the XRP community and an attorney by the name of Fred Rizzoli, have voiced their opinions regarding this topic, stating that there is no way that any additional lawsuit can take place. Following the receipt of the notice from the Wells, Consensus took the effort to register a complaint against the ASCCC, however. They did so prior to the SEC formally filing a case against them. Even though the Securities and Exchange Commission had stopped investigating them, they made the decision to sue the SEC on their own initiative. The Securities and Exchange Commission is currently facing challenges in its efforts to file new false claims against any member of the cryptocurrency ecosystem, including individuals in the Ethereum ecosystem. These challenges are preventing the SEC from filing such accusations. Due to recent events and the decision of the Supreme Court, which will eventually result in an increase in CRIP in the United States, it is less likely that the Securities and Exchange Commission would attempt to do such a thing. This is because the Supreme Court's decision will eventually lead to an increase in CRIP. An attorney by the name of James Murphy, also known as the Melalaman, wrote about the current litigation against Consensus that was filed by the Securities and Exchange Commission. Staking and swapping of MetaMasks are the primary topics of the complaint. The ruling that the Supreme Court made in the defense case against Chevron has been subject to criticism, because they were restricting the authority that the Securities and Exchange Commission was claiming to have, despite the fact that the SAC had never formally had jurisdiction over such matters. The judgment in the Chevron defense case, which was handed out by the President in 1984 and says that federal courts should defer to reasonable federal agency discretion in circumstances where legislation are ambiguous, was overturned by this ruling from the Supreme Court.